Hey everybody, Asset Protection Attorney Brian T. Bradley here, and I'm sure you are watching a lot of the videos and hearing me on the different shows and media that I've been on about asset protection and what to do and how to protect what you have. Today I want to talk about you California residents and series LLCs. And I want to do it starting through some charging orders and then work ourselves to series LLCs. Just to sort of help you out in your analysis and your thought process. Um, so when we're talking about charging orders and series LLCs and California residents, we look to a lot of the statutes like CCP Section 708.310 or Section 15673 or Section 15672, Section 17705.03 or 17701R. There's a lot more, and I know that means nothing to you and it's pretty boring to you. And what they bring up are a lot of interesting questions and concerns, though, and that's why I wanted to actually just throw those out there for you so you can look them up if you ever want to. And so now the interesting things that exist with charging orders is that there's not a lot of case law that actually exists on charging orders. It's pretty surprising. And really this is for two main reasons. First, many creditors don't find the charging order remedy to be a useful remedy, and they actually look to settle with the debtor or you, the person that they're suing, down the line. Instead of getting a distribution order in court, from the LLC or whatever your business entity is. And eventually it's just because lawsuits are expensive and it's in both parties' interest to eventually settle. Or second, the charging order is granted, but it rarely ever gets appealed. So the opinion that would be published by a court isn't actually published because there's no appeal or nuance of law for the courts to actually want to publish an opinion. And so most of the reported cases that we have deal with foreclosures that go to appeals. Cases that don't really go to appeal just really never get reported. But the California Supreme Court has a few cases that affirm the charging order. These are Crocker Nat Bank versus Peterson and Hellman versus Anderson. And the Crocker case held that partnership interest can't actually be foreclosed on. So you have a partnership interest in a business that can actually be subject to a claim. And the Hellman case, they state that consent from other partners isn't required. So you can have a partner that goes out and binds your company and your shares, and you're on the hook now. And so then we hear about a hot topic, with a lot of different options, the series LLCs, a really hot topic. These were adopted from offshore mutual funds to protect and segregate portfolios in the financial world. This is where instead of placing assets all into one LLC, you're placing single assets into child series or separate sale companies underneath the mother LLC. But the really big issue is that not all states recognize series LLCs, and California specifically does not have any series LLC statute and does not recognize them. And other states take their own individual stances on how much or how far they're going to recognize the separate entities. So even in those states that do have and recognize series LLC and have series LLC statutes and legislation, there's not a consistent consensus state by state on what they're going to do and how they're actually used, which is, for the asset protection world, uncertain. One of the main arguments against their use or the use of series LLC is just the amount of uncertainty of the recognition of the internal protection shield for foreign states like California that don't recognize them. And what I mean by foreign is you're a California resident going to like Texas or Delaware, a different state that has a series LLC. That's called a foreign entity. If you're involved in litigation in California, which if you're a resident of California, that's most likely going to happen, in recent published opinions that have interpreted California Corporate Code Section 17450A, this is what's known as the Internal Affairs Doctrine. What they've held is that that section does not apply to disputes that include people or entities that are not part of the LLC. So again, they don't apply if you're not a party to that LLC. So when you think about that, that would typically be any person suing you. we're looking at the Butler versus Adoption Media LLC case on this. And so essentially the internal affairs doctrine only applies and is interpreted to the internal affairs of the legal entity, your business, its internal structures and workings. And so it should have no impact on anyone outside of it. This comes from also the Bishop and Klingberg information on LLC tax and business law, and they're citing the Restatement Second, Section 302. So basically, what you're going to have in California is a case-by-case analysis and evaluation if you're trying to use a series LLC, and then weighing the injuries that are suffered by the person saying, suing you, and how disregarding that internal shield would actually help remedy the plaintiff. But given the fact that it's California, and you can think of many situations where in California, a California court will find an overwhelming interest or a public policy to apply its own California state law. So for California residents, when you look at the statutes and the law and the opinions, I wouldn't recommend a series LLC for a California resident or for anybody who's a resident of any state that does not have a series recognition or series LLC statutes in that state. I personally only recommend using series LLCs for people who live in states that have series LLC legislation and the assets that you're looking to protect reside in a state that also has series LLC legislation. Otherwise, it's just not worth the risk. And for income tax purposes, California is not going to give you any breaks. California is going to treat each series as a separate taxpayer and also separate franchise tax per child that you create. So it's really just more of a bookkeeping concept, but think about it. It makes sense though. Just think about it through what it came from, mutual funds and finances. It's for more of a streamlined bookkeeping situation. So I hope this helps clear up for you California residents, the series LLC debate. And if you have any questions, just jump on my website, www.btblegal.com, and I have lots of videos and media that you can go through to learn about different levels of asset protection and brochures and pamphlets. Feel free to email me, Brian, B-R-I-A-N, at btblegal.com. I like to answer people's questions just so that you have an education to make a decision properly. Again, thanks for listening, and I hope this clears up some pretty interesting and new concepts that are highly debated, and people are just not getting much information on what's actually going on and some law behind it. Thanks, and have a great day.